It's great to be here at the home of the Blue Devils. We are thrilled and very happy to be joining you for our oral arguments here today. My name is Andrew Mead. I'm the Senior Associate Justice of the Maine Supreme Judicial Court. Ordinarily, our Chief Justice, Valerie Stanfill, would be sitting in this seat and conducting these proceedings, but she has been hit by a bulldozer of a cold or virus and is very sad that she can't be here today, but she sends her best regards to you. She will be participating in all of the cases we're talking about here today because we are live streaming this on the internet and there's also recordings of it. So that will be our full panel. Again, it's great to be here today. The cases that we're going to be processing are real cases. This isn't a skit or some sort of TV courtroom going on. These are real people, real issues of law that we'll be addressing as we do year-round. This is always a pleasure for us to get out and about. I'm joined here by my colleagues on the court. Ordinarily, we have 7 justices of the Maine Supreme Judicial Court. We are down 1 awaiting an appointment, and as I said, the Chief Justice is unable to join us here today. Before we get started, I'd like my colleagues to introduce themselves. We'll go in order, reverse seniority order, as we typically do, and Justice Douglas will lead off with the self-introductions.
Thank you. Good morning, everyone. My name is Wayne Douglas. It's a pleasure to be here. Thank you for having us. I have been a judge for a little over 20 years. I started out on the trial court, and I have been on this court for about a year and a half. And my chambers are in Portland. We don't have one building where we all sit in, but we have chambers or offices throughout the state, and I happen to sit in Portland. Thank you.
Morning, everyone. I'm Associate Justice Rick Lawrence. I have been a member of the judiciary for about 24 years. 22 years were spent on the district court, and I've been on the Supreme Judicial Court for the last 2 years. My chambers are situated in Portland, and very happy to be here, and hope you will all do gain some insight as to how this branch of government works during the course of today's proceedings.
I am Catherine Connors, and I am the only one of any of the justices who was never a trial judge, and I've been on the appellate court here since February 2020. Before that, I was in private practice. I'm from York, and my chamber is in Portland.
Morning, everyone. My name is Andrew Horton, and I have been a judge since 1999, long time, and I've been on this court for about 4.5 years. I came on in February of 2020, and before that I worked in the trial courts, and before that I practiced law with a law firm. And as you can see, we're sitting up here in order of seniority. Justice Connors and I have been on this court longer than Justice Lawrence and Justice Douglas, and Justice Mead has been on the longest. So as you stay on the court, you move toward the middle of the seating arrangement. I was sworn in actually 15 minutes after Justice Connors was at the governor's mansion in Augusta, the Blaine House. And under the normal rules, because she was sworn in first, she would be considered senior to me, and she'd be sitting where I am, and I'd be sitting over there. But because I was a judge for 20 years before I came on this court, I was considered to be senior. And anyway, I'm fine with it, but not everybody is. So anyway.
So and you're moving closer to the middle all the time.
Yeah.
One step at a time. All right, well, you've met my colleagues. As I said, my name is Andrew Mead. I've been a judge for 34 years, the last 18 of which have been on the Maine Supreme Court. I want to acknowledge some important folks who are here today joining us. If you are present, would you kindly stand and give us a wave to confirm that? The first of which, unfortunately, can't join us here today. Senator Peggy Rotundo is back doing her job back at the legislature. They're swearing in some new judges, so we said we fully understand and please thank you for that. And also we thank her for the invitation to be joining you here today. We have some other legislators joining us here today. Representative Margaret Craven, she's giving us a wave down front, and Representative Mana Abdi, giving us a wave also. I also want to acknowledge and thank Jonathan Radke, the principal, if he is here, or he's attending to his duties as he should be. Also recognize Representative Adam Lee, who is a member of the legislature, and he is the lawyer of the day. He's going to be helping walk you through what's going on here with us. We thank you very much for that, Representative. I also want to thank the coordinating faculty, including Doug Dumont, the assistant principal, Jeff Burkhart, SRO, and Jason Fuller of the athletic department. We also want to give a nod to the custodial staff and the folks who helped with the AV setup, absolutely critical to what we're doing here today. Also, I want to recognize, going too fast here, Representative Kristen Cloutier is present. Thank you. Also want to acknowledge and thank the Blue Devils football team who actually set up the chairs here. Absolutely perfect, impeccable detail. If they're executing all their plays with that level of detail, you're in great shape. So, we're going to get started in just a moment here today. We are an appeals court. We don't hear trials. A lot of us were trial lawyers and trial judges before we got here. But if someone has a case in the court and it doesn't come out the way that they had hoped, they have the right to appeal that result up to us. They have the burden of demonstrating to us that something went wrong, the law or the facts down below. And if we're satisfied they've sustained that burden of proof, we can vacate, meaning we can sort of wipe the slate clean and send it back down or make some corrections in what happened there. This is not Judge Judy. This is important stuff. We are the court of last resort. It's very important we get it right, which is why there are 7 of us who make the decision, because with a very small exception of cases that can go to the United States Supreme Court, we are the end of the road. So this is very important business here, and is very important to the parties concerned. So, with that said, I think I've covered all the preliminaries. We're ready to get started with our first case on the docket today, which bears docket number Penobscot 24-36, State of Maine versus Richard Kelley. The matter is on appeal here today. I'm going to ask the attorneys who will be arguing if you would kindly stand in place and give us your name and the party you represent. First for the appellant.
Good morning, Your Honors. Hunter Tzovarres. I'm representing the appellant, Richard Kelley.
Thank you, Attorney Tzovarres. And for the state?
Assistant Attorney General Ann Sibley, Kelley, State of Maine.
Thank you, Attorney Sibley. We are ready to get underway, and Attorney Tzovarres, we'd be happy to hear you on your appeal on behalf of your client.
Thank you, Your Honor. Good morning again. Let me just take a moment to set the stage about what happened and what we're deciding here. The state got a warrant to track a vehicle, a Dodge, and they got that warrant and they stuck the tracker on the car, which is a GPS tracker, would track everywhere that car traveled. Richard Kelley was a regular passenger in that car. He spent hours, and if you added them up, it would be over days in that car, traveling sometimes 10 hours at a time in that vehicle as a passenger. And everywhere he traveled was being tracked by that warrant. And Mr. Kelley said that he had a privacy interest in his movements in that car as a regular passenger. Moreover, Mr. Kelley also had a special relationship to that car in that he stored his personal property and his work property. He was a fisherman. He had a sea bag that he kept in that car for not just when he traveled in it, the record said for about a month. So he had some other special privilege when it comes to this vehicle. So eventually, based on this warrant, the state got other warrants and they stopped the car and then they searched the car that Mr. Kelley also kept his belongings in, and they found drugs that they want to then use against Mr. Kelley as evidence at the trial. Now, before we got to the trial, Mr. Kelley believed that his rights were violated because the warrants were unconstitutional, which really isn't the issue today, I don't think. But he filed that motion. He wanted the court below, the trial court, to decide that. The state, through the Attorney General's office, after they heard from Mr. Kelley testify about how often he traveled in that car, what his special relationship was to that car, the state said, we agree that he had a privacy interest, so the court should go ahead and decide whether these warrants are valid or not. But the trial court, even though the state didn't ask for it, said that Mr. Kelley can't challenge these warrants because he doesn't have a privacy interest in the car. And we're asking that this court send it back to the trial court to decide whether these warrants were valid or not, because it's not even disputed, and the state agrees that he had a privacy interest in that vehicle, and that's really the right call as well, based on how often he traveled in the car, how we're talking about GPS tracking in his movements, and because he had that special relationship to the car where he essentially used it as a storage facility for his property. So, Your Honor, at this point, I'd welcome questions from the court.
Now, to set the stage here, as we know, if a person has a place, a physical place, in which they have a privacy interest, law enforcement can't intrude in the absence, in this case, of a warrant. Is that correct?
Ask that question again. Maybe I didn't understand it.
Okay. If a person has a place, a house, a garage, a car, and if that person has a privacy interest in that place, the police cannot intrude, at least in this case, without a warrant, correct?
Correct.
So if they do, and if the person believes that warrant, something was wrong with that, they shouldn't have been able to come into my place, they can challenge that in court.
Right.
And that's, in fact, what happened here. But the key to this is that your client must have had a privacy interest in that vehicle. Is that so far so good?
I agree.
The owner of the car probably has a privacy interest because they own it, but he was a passenger in this car. Tell us why just being a passenger in the car would give him a privacy interest that would give him the right to challenge the warrant for the car.
Sure, I can answer that question for Your Honor. It's because Mr. Kelley was more than just a passenger. He was a regular passenger, spent hours in the car traveling. And remember, too, in this case, we're talking about tracking his movements while he's traveling in that car.
Why was he more than just a passenger? He was sitting in the passenger seat, wasn't driving. He was going to a place where the driver was driving. What makes him more than a passenger that would give him the right to challenge the warrant?
Well, the courts said that you have to be more than an occasional passenger. So this isn't as in the Lovett case that the court decided the person didn't have standing as a passenger, where the record seemed to indicate he was a one-time passenger. But I think what really sets this case apart is that he had a special interest in the vehicle, a relationship with it, by storing his personal property. That makes it more like a garage or a storage facility, and the fact that he kept his property in there and had the authority from the owner to do that. So I think that's what separates it from just the pure passenger cases. And remember, the Supreme Court in Jones said that tracking someone's movements is a search. So the fact that we're not just dealing with him driving along the road, stopped for speeding, the car is searched, that would be different, perhaps. Here, the government wants to use all of or the government tracked all of his movements while he's inside the car with a GPS. So that makes it different, too, than the Lovett case or some other cases.
I have two questions for you. One is, was there specific evidence that Mr. Kelley had been a passenger in this car while the tracking device was attached to it?
Yes, I believe his testimony covered the period of time when the tracking device was on the car. So I do believe that's in the record, and it wasn't disputed by the state.
Right, and there's no evidence that the car itself was searched. I'm not sure where Mr. Kelley kept the sea bag, etc., but there was never any search of the vehicle itself during the tracking period, was there?
Well, I believe there was, because the vehicle was stopped while it was still being tracked, and the warrant was executed at that time, and the vehicle was searched in full at that time. And then that's when the drugs were found.
Was Mr. Kelley in the vehicle at that time
Yes,
when the search was executed?
yes.
One of the things that you find concerning, if I understand your presentation correctly, is that the trial court ignored the state's concession that your client had demonstrated a privacy interest.
Right, absolutely. I think we shouldn't even be discussing this, frankly, because it wasn't an issue below. The state essentially didn't throw the challenge flag on that, and the court nonetheless took it upon itself to review it. And this court has said in the Maloney case, which I cited in my brief, that on a motion to suppress, which this was, of course, that if the state disputes that the person's rights have been violated, then it's the burden of the defendant to establish it. Here, the state didn't dispute it. They conceded it, and the court even said the stipulations noted at the time.
Well, that leads to my next question then. Is there any contention on your part that your client didn't have a full and fair opportunity to present his case as to why he had a privacy interest?
Perhaps if we knew that the court was skeptical of it or was still going to take it upon itself to decide the issue after the stipulation, perhaps we would have wanted to develop that further and evidence further. But when the state said they're stipulating and the court said stipulation noted, it became, I guess, a surprise that it was addressed and that there was even a motion to reconsider filed on that.
But again, the state's concession came as a result of your client's evidentiary presentation.
Correct, correct.
As you stand here today, are there other facts or circumstances that you feel were not properly addressed or adequately addressed by the court at the hearing?
I think the record is developed enough on this issue and clear enough that standing has been established and that the state was correct in stipulating to it. I do think the court made some, or perhaps the court's reliance on the Lovett case was somewhat misplaced because the court said it could always decide standing, and it actually said in its decision when I reviewed it this morning that in Lovett, standing wasn't disputed, and this court found that there was no standing. But that's actually not accurate. Is in the Lovett case, it was disputed below.
The state disputed it below.
Right. Trial court didn't address it, and then this court addressed it on
But
the appeal.
you have not identified any additional evidence you would have shown in any of the arguments, because the stipulation didn't come until after you had presented your case showing why you thought he had an expectation of privacy. So that's not in the record of any prejudice, because had you known they weren't going to stipulate, they didn't stipulate until the end of the hearing.
On that issue, you're correct, Your Honor. And I think that the record from what was established from Mr. Kelley's testimony established the standing.
Okay, let me ask you a question that's somewhat abstruse, and it's going to be the same question I'm asking of the other side, but they get a heads up to think about it.
All right.
There are two constitutions, the Fourth Amendment and Article 1, Section 5, the U.S. Constitution, expectation of privacy protected by the Fourth Amendment. Maine Constitution, Article 1, Section 5, protects it. You alluded to the Maine Constitution, but you didn't develop an independent argument under that. So I want you to assume that we are only entertaining a federal Fourth Amendment argument. Whose standing law do we look at in reviewing a Fourth Amendment standing argument? Do we look at federal law, or do we look at Maine law as to the impact of the stipulation, the scope of the expectation? Which law applies?
Maine law, Your Honor, because this is a Maine case and it's as whether they're standing in the Maine court.
It's a federal claim, though, and wouldn't the federal Constitution govern the scope of the expectation of privacy in order to make a standing claim under the federal Constitution? It's a hard question.
Certainly the court can look at both, right? And I think under either standard, that the standing has been met here. But because we're talking about a Maine court and whether essentially the doors of the courtroom are open for this person, the court could look to Maine law as to whether there's standing in this case as well.
And the Lovett case did cite to the
I'm sorry, it's just hard for me to hear in here. Maybe I'm getting older. It's just the acoustics.
It's not you. It's probably me. The Lovett case did cite to federal authority as well. It cited the Rackus case for the
Right.
proposition that the defendant has to have a possessory interest in the car.
Right, and you can decide it under that standard, and this is completely different than the Lovett case for a number of reasons, but particularly because of the storage of the property.
So the two reasons that you think it's different is, one, he had a sea bag, he had some personal item in the car, and two, he rode in the car more often. Are those the two salient facts?
And third, that there was the GPS search throughout of the tracking. It wasn't that this was just a search at the time of the stop, which would have been in Lovett. And it's more than just having the sea bag in the car at the time he was driving. Remember, the record says that Mr. Kelley kept the sea bag in there for, I believe it says, approximately a month. So this is more like storing property long-term than just having his backpack with him when he's traveling one time in the car.
Was anything discovered?
Yeah.
Was anything discovered in the bag?
No.
And I see the red light is on, so that completes your time in Central, but we will be hearing again from you on rebuttal shortly.
All right, thanks, Your Honors.
Thank you. And Attorney Sibley, we'd be happy to hear you on behalf of the state of Maine.
Thank you, Justice Meade. Your Honors, may it please the Court. The primary issue before this Court today is, as identified, whether Mr. Kelley has a reasonable expectation of privacy and thus standing to challenge the search of Keith Wedge's Dodge Charger on February 22nd, 2021, which resulted in the seizure of a Class A amount of fentanyl powder. The U.S. Supreme Court, the First Circuit, and this Court have repeatedly held that a mere passenger who has no possessory interest in a motor vehicle itself has no reasonable expectation of privacy and thus no standing to challenge a search of that vehicle. Here, Mr. Kelley has no reasonable expectation of privacy in Mr. Wedge's vehicle. He asserted no ownership interest in that Charger, and in fact, he never had even driven it. And contrary to his assertions, a handful of trips, even a few to Massachusetts, and storing a small bag of clothes in that Charger for a period of time is neither equivalent to borrowing a motor vehicle from its owner, nor is it sufficient to establish a possessory interest in the Charger itself. And even though the state was wrong that the evidence presented at the hearing supported standing, the state's error did not prevent the trial court, and it does not prevent this court from affirming the trial court's decision on the correct basis, which is that Mr. Kelley has no standing. I'm happy to take questions at this time.
Obviously, the first question any court asks in any proceeding is whether or not the person before the court has the authority, has the standing to make the point they're making. And here the court below said, no, he doesn't have standing, so that kind of closes the door on the rest of things. I know we'll want to talk about that, but I want to jump ahead to what he would argue if he actually was going to argue the case. Can I ask you some questions about that? About the warrants themselves?
Yes, Your Honor.
Okay. Now, the warrants here are kind of unique because these were warrants to put a tracking device on a car so the police could see where the car was going from place to place. And if Mr. Kelley has the opportunity, he would challenge that and say, no, that warrant was improperly given because there wasn't probable cause. So if the judge agreed with that this warrant, no good, throws it out, it looks on the face of it that there was actually other evidence that had nothing to do with the warrants. For instance, the state knew of some people who dealt with Mr. Kelley, said he's selling drugs, I bought drugs in the past. And in fact, there were apparently 2 actual buys that the state was supervising there. Does it make any difference to the state whether this, we're getting way ahead of ourselves here, but if it comes to this and the judge says to you, does it make any difference whether this warrant stands or falls because you've got 2 buys that would be admissible in evidence?
Well, the 2 buys were with Mr. Wedge, not Mr. Kelley. So the warrants are important here in the sense that they lead to the motor vehicle stop where Mr. Kelley is the mere passenger in the Charger with Mr. Wedge, who are the targets of the actual
That's right.
investigation.
I'm sorry. The actual driver was apparently engaged in drug trafficking, and it was very clear regarding him, so that would support the warrant. Was there evidence regarding Mr. Kelley that would support a conviction separate and apart from what they learned from these warrants?
Not that I am aware of and not that I believe is in the record before the court.
So it makes a big difference whether these warrants stand or fall?
Correct.
Okay. All right, we can circle back to the issue of standing, and I'm guessing my colleagues will have some questions on those.
Actually, I'd like to take up the warrants a little further. Is there an issue with respect to the tracking warrants to the in terms of them being in violation of 639 sub 4, to the extent that they were tracking the vehicle when it was outside the state of Maine?
That statute does allow that. The most important thing is that the tracker needs to be installed within the jurisdiction of Maine. There is no evidence that this tracker was installed outside the jurisdiction, thus in violation of the warrant.
I have a question about the stipulation, and for everyone's benefit, a stipulation is an agreement, and it's very often, during a trial, the attorneys for the people involved in the trial will say to the judge, we stipulate, meaning we agree on something. And here, the state's attorneys told the court that the state agreed that Mr. Kelley had standing. In other words, that he had the right to contest the warrant and argue that the search was illegal. And these stipulations happen all the time. The court doesn't have to accept a stipulation. The court doesn't have to, even if an agreement is presented, the court doesn't have to accept it. But here the court said stipulation noted, which sounds like the court was accepting the stipulation. And I guess I'm concerned about precedent we would set if we said a stipulation that appeared to be accepted by the court wasn't binding. That's question one. Question two is, if we say that the stipulation was binding and therefore the court should have agreed that Mr. Kelley had standing and gone on to address whether the warrants were valid or not, should we decide ourselves based on the evidence presented, whether the warrants were valid or not? Or should we, as Mr. Kelley, I think, is asking, send it back to the trial court for the trial court to decide whether the warrants were valid?
As to the first question, Your Honor, I believe the trial court statement can reasonably be interpreted as just noting that the stipulation was part of the record and not necessarily, I accept this stipulation as fact. Even still, standing is a threshold question for all of the courts, and just as this court didn't love it because neither of the parties had argued it, the trial court hadn't brought it up, and I believe in Blanchard as well, even though that wasn't a criminal case, brought up standing sua sponte because it is that threshold question. So even though the state erroneously agreed, it was important for the trial court. It was the trial court's duty to independently assess whether the evidence was sufficient to establish standing. And this court can do the same. This court, I believe, pointed out in both cases, is not bound by the trial court's determination.
It seems to me there's two possibilities would happen when there's a stipulation. As Justice Horton pointed out, stipulation means handshake. We agree that the defense and prosecution agree to something. Now, if, let's say in a trial that the state and the defendant agreed to something, so the state or the defendant figures, okay, I don't have to bother with that because they've already agreed to it. So I have great evidence, but I don't need to put it on because it's already agreed upon. Then it comes down to crunch time, verdict time. The state says, we withdraw our stipulation, don't agree. And the defense says, wait a minute, I had a great case and I didn't put it on because we agreed. That would be one situation. Situation two would be where the parties enter into a stipulation, but the evidence has already gone into the record. And the state says, oh, okay, now that I hear everything you've said, I agree to it now. Do you agree that in the first case, that would be an injustice to require the defendant to roll over and without the evidence? But in the second instance, the defendant would have had an opportunity to put the evidence on, even though the state ultimately agreed. Is that a valid distinction between the two?
Yes, it is, Your Honor. I would completely agree in the first instance that would be an injustice. That's not what occurred here. What occurred here was that the evidence had already been presented, and this, to the state, isn't an issue of whether the state waived its argument. Waiver expressly, it applies when a party expressly waives and then fails to prevail at the trial court level.
So you say there's no prejudice here to the defendant. They put the evidence on. Mr. Tzovarres may disagree, but your point is they did have an opportunity to put the evidence on.
They put all of their evidence on to show it before the state erroneously agreed that that was sufficient. And
now you're arguing to the contrary here. You said I agree to this, but now I'm defending the judge's decision that there was no standing. Is that uncomfortable?
It is, especially when I was not the attorney
okay.
below.
All right, we'll move on then. Okay.
So let's get to my question that you now had time to think about. Is the standing issue, when it has to do with the expectation of privacy, is that a state law question or a federal question when it's a Fourth Amendment issue?
Well, in this case, it's a strictly federal claim because an argument under the Maine Constitution was not developed properly,
right,
either at the trial court or here.
But do we apply the federal rules about standing? Well, I mean, you said this is a threshold issue. We can raise it sua sponte. The state law to get into court standing is different in state court. It's prudential standing in Maine, while it's Article 3 and there's jurisdictional standing there. But it's also a component of the expectation of privacy, which is the claim itself. So it's not really the threshold standing issue, which sounds more like state law to me. It sounds like it's more a component of the federal one. And if it is a component of the underlying claim, then does a stipulation have a different weight and you don't raise it sua sponte and it's a question of party presentation?
I believe it in either circumstance, even in the federal interpretation, standing is still a threshold issue that that federal courts address well. So even though this court is addressing a purely federal claim, standing is still something that should be, that the trial court properly considered and that this court should consider as well. As far as the law going forward to apply, as this court has done before when it has strictly federal claims, is to look at the federal law and even still look at Maine law. For instance, in the Lovett case, in ruling that there was no standing, there was no reasonable expectation of privacy, this court relied on the U.S. Supreme Court decision in Raucus versus Illinois.
So what would have happened if he was homeless and he was living in the car? Would that make a difference?
It could potentially, Your Honor. There may be a different type of possessory interest. What we have here is, I believe, testimony that he traveled about 5 times in the vehicle over the course of a few months. Went to Massachusetts on a few trips, but the First Circuit in the Simonovich, I hope I'm pronouncing that correctly, case said duration may matter, but they found the trips from Maine to Massachusetts not sufficient, and the small bag of clothing. This wasn't a situation where Mr. Wedge allowed him to live in it, where everything that he had was contained within that vehicle. What
if they had searched the bag? Does he have an expectation of privacy in the bag in the car?
Well, if it is his, in some ways, yes, but in the Simonovich case, the defendant in that case said that the tire inflator can that was underneath the passenger seat, that belonged to him, and the First Circuit said, yeah, but it was in the vehicle under the passenger seat where you didn't have a reasonable expectation of privacy. Also in this case, there was a warrant to search the actual vehicle, for certain items, and if items that were allowed to be seized under that warrant could have been concealed within that bag, then under the warrant, they would have been able to search as well.
Yes, but he might have standing, wouldn't he? If he has a possessory interest in the bag.
He could, but what's at issue in this case is the search of the whole vehicle, not the bag.
Well, what about the trunk, where he keeps the bag? And what I'm understanding is that he stored it there for a long period of time, or for some period of time. He's going in and out of the trunk. Does he have an expectation of privacy in the trunk?
I believe the testimony was that the bag remained in there for about a month or something like that. I don't recall if the bag was actually in the trunk, but it's really good timing. Again, in this circumstance, Mr. Kelley had no possessory interest in the entirety of that vehicle.
Understood, but this is different than Lovett, because in Lovett there was no evidence at all here of any kind of possessory or other connection to the vehicle. But here there is additional evidence, which we've been talking about.
I would argue it's not that much
Not
additional
enough.
evidence. It would be it would be akin to if I rode in a friend's vehicle and I happened to leave a bag in there and then I forgot about it and remembered. I now have a possessory interest in the vehicle. I think that's too far of an extension that both the Supreme Court and this court have taken the reasonable expectation of privacy and what a possessory interest for a mere passenger means.
Well, I'd ask opposing counsel if anything was found in the bag. And in this circumstance, do you know if the bag was searched?
May I answer, Your Honor? I do not recall off the top of my head. I would think, just based on my general experience with these, that law enforcement likely searched the bag.
Thank you.
Thank you.
And Attorney Tzovarres, you have the burden, so you have the last word in rebuttal.
So when we're talking about a reasonable expectation of privacy, the question really is, does anyone really think that when they're traveling around in a car for hours, that the government is tracking where they're going, knows where they're going every minute of the trip? And if someone is going to leave all their leave some property in the car, and they are going to keep it there. So I'm glad I got one too.
You got one too.
And
okay.
If they're going to keep it there, do they really think the police are just going to be free to go and search that car? They don't have some privacy interest in the place they're storing their property. And I don't think the law that's what the law means. And all the cases the state cited are all different than this case. They don't have the facts that we have in this case.
But I guess I'm missing the connection. Because the car was being tracked, why does that create a reasonable expectation of privacy on behalf of your client?
Because he's a passenger traveling in the car, and the U.S. Supreme Court said in Jones that the tracking of someone's movements in the car, it was a car in that case too, I know it was the driver, but it said in that case that the tracking itself is a search. So they said that's a search. So that's a search, just the tracking alone, not
Okay.
even the...
But he has no ownership interest, correct?
He doesn't own the car. Right.
Doesn't even drive the car.
Right.
He's simply a passenger in the car on a number of occasions.
Right.
Some of those occasions, there was a tracker that was keeping track of the whereabouts of the vehicle.
For months, right. Right. And as far as your question earlier about if the court should decide this on the merits of the rest of the motion, I would suggest it's premature to do that because the court below didn't make factual findings, didn't make conclusions of law, and there was an open question the court never decided. There was a motion to reopen filed as to whether the warrant was also defective because it was issued for 60 days when the statute says it can only be issued for 30 days. So if you find standing, it should be decided by the trial court before you take a look at it.
Thank you.
Thank you.
All right, that concludes our oral argument in this matter. We'll take the matter under advisement and issue a decision in due course. So you may be wondering, what the heck does that mean? Because you want to know, does Mr. Kelley have a privacy interest in this vehicle that would give him the right to challenge the warrant? I made a good point too, to challenge the warrant. And that's a big deal because it concerns whether this prosecution goes or doesn't go. What happens next is that the 6 of us, including the chief, will gather and we will confer on this. We'll lock the door behind us and debate with each other. We may have different positions on it. If we all agree on the result, we issue what's called a unanimous decision. 6 of us sign on. Sometimes some of us disagree with the position the other has taken. In that case, the majority prevails. The majority opinion carries the day, but the ones who disagree can write something called a dissent, where they say, I think you're wrong about that, and this is why. That's the next steps in this matter. I think at this point here, Counsel, if you're willing to stick around for a little while, just in case there's any questions from anybody who attended here today, and Attorney Lee will facilitate that process there. So I think that covers it all. So again, thank you very much. Pleasure to be here, and court will be in recess.